Hey, Miss Jill, good morning to you.
Good morning. I'm sorry I'm in Chicago visiting my daughter.
No problem. I'll try to catch you before 9 because I know the phone starts
No, it's
ringing.
okay. Here's the problem. Well, you tell me what your thoughts are, and then I'll tell you mine. How about that?
Okay, that's cool.
Go ahead.
Well, my thoughts as far as me sitting down and calculating the numbers, that won't even pan out to only like pay me for like a year of my salary, and after that it's just pretty much for me to be back at square one, back at where I'm at right now, pretty much, because this whole process done put me in a hole. Buying a truck and starting my own company, my own business, and I'm just barely out my first year of that, and I'm barely on my feet right now, and I'm still struggling. So
here's the world according to me. We are trying to, as much as possible, make this a non-taxable event for you. Which means that you need to take whatever net money, which would be about $120,000 that you get, and multiply it by at least a third, if not half. Because if you had earned that amount of money, you would have taxes taken out of that amount of money, which at that level would be about 40%. That's number one. Number two, I've looked at your file and stuff, and you had not yet vested for retirement, which was something that you had indicated in your text to me and to Brett, with the loss of retirement. I know that those funds are probably still there somewhere.
Yeah, they're there.
In terms of, right. So that's not going to go anywhere, but you hadn't vested.
No, right, correct.
Hold on, let me get my notes. Hold on. Sorry, Carl.
No problem.
So what I looked at, hold on, let me get it. Ugh. Okay, hold on. Okay, here we go. Oh, no, hold on. I'm looking.
Okay.
No, I can't put my hands on it. Give me 1 second.
No problem. I ain't in a rush. I'm good.
Anyway, I kind of understand what your thoughts were, but when I put pen to paper on it, it's not exactly the same. Like the termination date, okay, here we go, my notes. The termination date is January 31st, 2022.
Correct.
Your salary at LSP when fired was $60,815.48 a year, or $1169.53 a week, which came out to be, this is just rough calculations, $29.23 an hour. The lost wages from your enforced leave were $2,279.94. Your lost wages from the suspension were $5,848, and the lost wages since termination were $35,085.90. So the total lost wages from the discipline and the termination is $43,213.84. However, as of February of 2022, Brett tells me that you had told him that you were making $5,000 a week.
Correct. With the last people I was with, but I told him this week will be my first week. Under my own authority, under my own wings as a owner operator.
Right.
So,
but the point to that, Carl, is that when you obtain replacement wages, which the law requires you do to mitigate your damages on the wage component, when you mitigated your damages, you did so. And it's not a bad thing; it's a good thing.
Correct.
To the point that you have no lost wage claim, except for basically 1 month.
Well, my thing on. Go ahead.
Well, actually, you don't, because it started in February 2022, and the termination date was January 31.
Go ahead.
So
okay.
Go ahead.
So my thing with that was, Ms. Joe, I'm trying to catch you while you in that, because I'm going to lose my train of thought. On the trucking side of things, I'm not a truck driver. I did that because of my situation, with state police. So, it took a time away from the family and all that, things like that, and caused the trickle down effect. Now, I don't want to be a damn truck driver, you know what I mean? But, I did what I had to do to like you say, offset my losses or whatever and get a new job. But, of course, still going forward with law school as my plan was before all of this shit happened anyway. But I don't want to be a truck driver. And it's still, strenuous. It's still, having to take time away from family and all that shit like that. Too much time that I didn't want to take away from and result in losing, custody of my daughter, and then my last two upping and leaving. But of course, that probably has little or nothing to do as far as what we're talking about right now. But what you saying that I went and got a job as a truck driver making more, yeah, that may be true, but that's not a steady salary. That's not a steady salary. It's me depending on me getting out there and busting my ass and doing that labor to get there.
And look, Carl, I don't disagree with you. All I can tell you is what the law says.
Correct.
And so, I mean, that's all I can tell you. So I can tell you from a legal standpoint, if I look at your lost wages from the discipline, and I can sort of look at the termination, but I can't. Mm-hmm. Because even if you win in the state police commission and you go back to work, the law requires that we submit an affidavit of wages earned since termination, which offset against your terminated wages, which is going to offset those to zero.
Well, I would be more comfortable with that because I'll still have a steady check coming in that I don't have to, it's not contingent upon me going out and.
There's no way in hell. I mean, I'm just telling you straight up. There is no way, even though I believe that you should be reinstated, even though I believe the termination was horseshit, you've seen that commission. And for better or for worse, in my opinion, I feel like, I don't want to say the fix is in, but you know what they're doing. They're doing crap like making decisions about, the commission decided to do this. They want you to produce this. And I'm like, when the hell did they meet?
Correct.
And I feel like, from my perspective, that I don't see them necessarily reversing the termination. I see them reversing the enforced leave if they determine that the enforced leave was in fact disciplinary. But that's problematic on its own from the standpoint that that's going to be relying on David Cameron and a couple others. And granted, we have some recordings which help us, but they're not entirely dispositive. And so when I look at your case and I look at the number of 200, which frankly we submitted to them in good faith. This is the amount of money my client will take to settle his claims. When I look at that number, I can't say, Carl, in the 32 years I've been doing this, that that's a bad settlement. It is on the higher end of settlements in my world, on the way higher end. The average settlement in employment claims is somewhere around $50,000 to $75,000. And so when I start breaking it down on a practical level, and I see, okay, let's look at the lost wages. The lost wages, in my opinion, on your best day, are basically $8,000. The $58.48 and the $22.79. That's what I see. In terms of the reversal of the termination, they're willing to do that, which, they should, frankly. There's not going to be an impediment to going to work anywhere else except for state police. And that's something that, for better or for worse, Lamar is consistent about. And, I honestly believe that a lot of this is being driven by the fact that they have destroyed those text messages, and we played it very well in terms of the State Police Commission and stayed on their behinds to make that issue be laid bare in the record. That's the fact. On the other side, when I look at your whistleblower claim, particularly as it relates to the enforced leave, and I think even as it relates to the suspension, a lot of that depends on who knew about Toussaint Louverture, and was it the people who made the disciplinary decisions? Mm-hmm. I know there's a number of people who did. One or two of them are in your chain of command, but I will bet you $200,000 that their testimony is going to be, we never told them. And so while you were harshly disciplined and while you suffered what the law calls an adverse employment action for the purposes of a 1983 First Amendment claim, mm-hmm. At the end of the day, unless you can prove that the person who made the decision, which is Lamar Davis, knew that was you, took action because of what you said, you can't prevent. I also am concerned about where we go in this particular case from here if it's not settled.
Gotcha.
As I said, in good faith and, within the confines of an EEOC mediation, we submitted an offer that you authorized. And that offer is floating its way up through the state of Louisiana's, whatever it is, their people, for some sort of final approval. And it's extraordinarily difficult. It's not that I don't have clients who come back after we've submitted offers and, we've done all that kind of stuff and say, gee, I really want more. But the problem is that in the world of good faith settlement, that's kind of an enforceable deal. And so I guess at the end of the day, when I look at lost wages and I look at the fact that there was not a vesting for retirement yet, and I look at, all of those intangibles, the settlement number at $200,000 to me is an exceptional settlement. It's almost $250,000. That's what I see. I understand. I get it. It's not uncommon, that I have people who are like, well, wait a minute, I really, I've thought about it and I want to do this, days later, whatever it is. But I'm telling you, as your lawyer, this is a very good, reasonable settlement. I am very concerned that at the end of the day, with watching what I see in the U.S. Fifth Circuit Court of Appeal and what they're doing, they just issued a whistleblower case, a 1983 First Amendment case, where they dismissed half of it for no good reason. But we have the most conservative federal appellate district in the United States right here in New Orleans. It unfortunately in the last 5 years got stacked with a bunch of judges who really don't give a shit about civil rights. And so what I'm seeing as a trend line coming out of the Fifth Circuit is dismissing employment claims, whistleblower claims, discrimination claims, because they can, not because they should. And then beyond that, the only remedy you have is the United States Supreme Court, and that is only if they decide that your case is less than 1% of 1% of the cases presented to them on an annual basis that they want to look at. And so these are kind of the things that I think through when I look at settlements, whether or not they are reasonable, whether or not they're good settlements, whether or not they're in my client's best interest, and those types of things. That's what I see. I can also tell you that in terms of the settlements, as I indicated, yours is on the higher end of all settlements that I've had. It's not on the lower end, it's not on the middle end, it's on the higher end. And that's representative of the fact that when the state of Louisiana is weighing its risks, it sees it too has a problem. Frankly, in large measure, I would suggest to you because of the document issue. Because they know from a spoliation standpoint, which is me, and presenting the evidence and staying on their ass and, we want the emails, we want this, here's the numbers, here's the electronic preservation notice, all of that stuff, they know that the court very well could impose what's called an adverse inference. That's not the end of the day, but a jury would be instructed that they could presume that the emails which have been destroyed would reflect adversely on state police. That's pretty much the language of it. What that means, I don't know. Well, how a jury interprets it, generally speaking, they don't like people who destroy evidence. But as we heard in the legislative hearings, there's going to be a bunch of people up in there saying, oh, it's just an accident, we didn't mean to, this kind of thing. And then there's the notion of emails that relate specifically to your claim and emails that relate to the death of Ronald Green. And so if we look at the emails that relate to the death of Ronald Green, hell yeah, they destroyed a lot of stuff. But those relate to your claim only insofar as establishing the underlying violation of law, which is the death of Ronald Green was the product of unnecessary force. My guess is they're going to stipulate to that because they've got a dead trooper, and they've pretty much laid it all at his feet and blamed him. So then I have you and a spoliation claim that while I can make it, whether the judge allows that adverse inference to apply to your claim specifically or limits it only to the Ronald Green scenario, in which case we don't get to put before the jury all this really bad stuff for them, i.e. that they destroyed emails and text messages and it was, right on the heels of people asking questions, those types of things. So I'm not being Debbie Downer, but I want you to understand that it's not a situation that any of us take lightly on our side. And it's definitely one that, from my perspective, I've spent a lot of time, research, and effort kind of thinking through the pros and cons of your claim like I do with everybody. You know, I don't believe in just kind of telling people, you know, it's great, you're going to be just fine, everything's wonderful with roses. It doesn't work that way. Unlike most lawyers who, you know, and there's 1,000 of them who are willing to give you an opinion and say, oh man, no, you need to get this, you need to get that, blah, blah, blah. You need to ask them, when was the last time they ever tried a civil rights case? And the answer is probably never. It's not a car accident. It's not a, let me get an expert accident reconstructionist and, you know, that's going to solve my problems. You have to prove the two cases for the whistleblower claim and for the First Amendment retaliation claim. You have to prove that Lamar Davis himself took action against you because he knew that you were blowing the whistle on a matter of prominent public concern. My goal, and the thing I would suggest to you is, I would like to focus as much as making this a non-taxable event for you as humanly possible. Because that, to me, I think is the better deal. But I mean, that's me. If you tell me, Jill, if I go to trial, what's that look like? I'm going to tell you, I don't know. I really don't. I won a case that was a male-on-male sexual harassment case. After I won it, unanimous jury verdict, they awarded him $350,000, and the judge came in and zeroed the whole damn thing out. Zeroed it out. Because he said he didn't think there was enough evidence. So 2 years later, an appeal to the Fifth Circuit, when they reverse it and send it back, then he issues an edict saying he's going to grant their motion for new trial they had filed right after trial, and he's going to reduce it to $75,000. So we had all this fight over all that crap. And from my client's standpoint, a case that took us 3 years to get to trial was now at the 6-year mark. So I don't know. I mean, these are just things that I guess I'm sharing with you to tell you that there's no guarantees in litigation. And in fact, in this kind of litigation, it's entirely the opposite. And I know I told you before, 80% of these cases get dismissed before they ever get to the inside of a courtroom. Of the 20% that remains, 75% end up in unfavorable verdicts. I mean, it's abysmal. So that's all I can say to you. And that's, you know, those are my cautions, I guess, for lack of a better phrase.
Okay.
I wish that I could tell you. I mean, and like I said, you know, people are going to tell you anything that they think you want to hear. And they're going to tell you stuff that, oh, God, no, you should get more money, you should do this and that. I'd love for you to get more money. You know that. But I also can't sit here and tell you, hey, flush $200,000 down the toilet in the hopes that you might do better 3 or 4 years from now.
Well, I guess my question would be to you, Ms. Jill. Let's say we put the money aside. Of course, you know, we need money to operate in this life. Of course, I'm not saying put the money aside like we don't want money or don't need money. But for the sake of conversation, let's put the money aside. Will you fight for me in trial? You know, if I want to go forward, will you fight for me?
Carl, yes. I mean, I fight for everybody, and you know that.
Okay.
Have we backed down from any fight that we've had so far? Absolutely not.
Well, I would say let's go forward then, Ms. Jill.
But the problem I have, Carl, is you have placed me and my firm in a very difficult situation. You gave us authority to submit an offer in good faith, which we did. And I'm hearing from you this morning, you want to withdraw it against my advice. And so that ethical dilemma is one that I'm honestly going to have to visit with outside counsel and talk in generic terms about my ethical responsibilities. But it's hard. I don't know what changed between the giving of authority and the considered and deliberate efforts towards settlement and yesterday. But I really worry about outside forces.
No, it's just me rushing my decision on it. And me coming back, because I kind of went through these same thoughts in there with Brett, and he could confirm this with you. I told him also that, as we was throwing out numbers, like, hey, it's not really about the money, because he was telling me you can't get ahead on this. You can't use this to try to get ahead in life. I say, listen, Brett, it's not about money. We can go and take it through trial, because I really just want the things that, the evidence that we have, the evidence that I have in my possession, to just come out during the trial. And if I come out on the other end and just having to pay you guys and me coming out with nothing, I'm fine with that. I'm okay with that. I'm not a money hungry person. This is on principle. This is on principle, and on the principle of the fact that these guys, I wore the same uniform with honor and integrity, what these guys were supposed to do. And I understand that the system is tilted, is messed up. I understand I could go in and they could just kick my ass and flush me out and just tell me don't come back, have a nice day, and I leave with nothing. I get that. I will make sure you guys are paid.
But that's not it. So if I can address what you said.
Go ahead.
Okay. Number one, you indicated I want my evidence to come out. Well, excuse my French, fucking let it out. There's nothing that's stopping you from doing that. And a trial is not a place for your evidence to quote unquote come out. The reason it's not is because you will be lucky if there's one or two reporters in there. They can't have television cameras, and they're going to be reporting what they remember and that they're not sleeping through. I'm not being disrespectful. I'm being honest. And look, my husband was a television reporter for 25 years. I know. They're going to report half of the story, and not in a way that's necessarily favorable or unfavorable. Just, this is what happened today.
I guess
you have evidence, and there's no settlement on the planet that is going to restrict you from talking about it, from publishing it, from writing about it, from doing anything about it. Nothing. In fact, you are in a better position to speak about what happened, because they have to withdraw the termination, and they've paid you almost $250,000. And so no matter what they want to say about, we just settled it in the best interest of the state, that's horseshit. Sorry. It's a lot of money. And it's not something that they can walk away from and say, well, we just paid them off and it's done. They don't pay people $200,000 because they don't have a case. They don't do that. And it almost, as I tell a lot of my clients, it puts you in a position where you are speaking from authority. It's no longer an if about, did Carl do something wrong, and maybe that's why state police did it. They withdraw the termination, and they've paid you a substantial sum of money. It's not a question of if they did something wrong. It is a matter of they did something wrong. And that, honestly, that whole thing is something that they can't run from. You've heard it before, and the documents say we didn't admit liability, we settled in the best interest of the state. Bullshit, Carl. Bullshit. Plus, in trial, we have a lot of evidence, we have a lot of information, but not all of it is necessarily going to be allowed in. And that's because the rules of evidence kind of box us in terms of what we can talk about and what we can't. They box us in terms of the judges trying to limit information and evidence at trial, because they don't want to sit there for 6 days. They'd rather have it done in 3 days, and crap like that. From my perspective, it allows you to have a sure victory. These people paid me a substantial amount of money, and here's all the shit that I know about it. Here it is. You guys need to look at it, pay attention to me. This is what I have. It's no longer a situation where anything you say may be cast in doubt because you're in active litigation against these people and you have a motivation to shade the truth in your direction. It is you speaking from a position of clarity and a position of victory. And so I ask you to kind of consider that as well, because that is an intangible that they can't do a damn thing about. They can't. They can't take that away from you. And as much as they may try to say, oh, we tried to settle this case and, we just, come on, Carl. Who pays $200,000 on a case that's bullshit? Nobody. Especially not taxpayer dollars. So, that, to me, if the goal is I want the truth to come out, and I want people to know, well, I would suggest you do it in a smart way, which is from a position of power and authority and victory. And take out of their equation any ability for them to argue that you don't have a case. Or, look, we got a dismissal on this 1980, this one little claim. So, that kind of crap. Take all that out in Jill's world.
Yeah. I guess, and I appreciate that, Ms. J. And I tell you every time, I keep repeating myself. I'm not trying to be a hard ass to you or the firm. It just, when I think about the principle that, that I stand on, like I'm going to keep repeating, it's not about the dollar amount, but if I have to make it about a dollar amount, in my eyes, I'm taking pennies. I'm taking, a year's salary. I know we calculated to where I make $60,000 a year, but I can't name one trooper at state police that ever made their base salary because of overtime and things like that. It's always available, or it's mandatory because of natural disasters, yada yada, etc. So that's basically a year's salary, and then I have to pay all the bills that I've accrued, while I've been out and trying to, run this trucking company, and still haven't got on my feet yet. So I'm arguing on that side with the monetary side, but on just principle side, I can't, come out and as this person saying, I'm standing on this, as, for principle. You guys are settling for a paycheck. That's why you guys are quiet. You're not standing up for what's right and not saying anything because you're selling out for a paycheck. And here I am letting them throw fucking pennies at me and kick me in my ass and tell me get up the road. So how I'm looking at it,
okay,
from
I don't know where you got the notion of they're throwing pennies at you. I don't know who's telling you that, but I'm here to tell you. I mean, number one, that is just not the truth, Carl. It's not. I don't know who you talked to or what you're looking at, or I have no idea.
Miss Jill, I conference with myself inside of my own head. I didn't.
Oh, okay.
I hear you keep saying that I'm listening to someone. This whole process, motherfuckers been scared to talk to me. Motherfuckers been scared to talk to me because of the position I've taken. I can't talk to little to no fucking one. Nobody don't want to talk to me, let alone talk to me about some settlement or something. No one wants to fucking talk to me. So I can't talk to no one but you, Mr. Brett, or a guy, and who's the best person to talk to, or talk to myself. But I don't have to get advice from no one. I know how to add numbers, subtract, divide, multiply, and I understand from my lawyers, and I'm gonna lean on you for the law side of it. Because I don't know is a fraction of what you know, but
and I don't be disrespectful by any stretch of the imagination. So let me retool it in a better way. I have been handling these types of cases for 32 years. I have been litigating against the state of Louisiana for 32 years. I am one of a very small number of people in this country who do this kind of work on a regular basis.
Yep.
When I tell you that $200,000 is on the high end of all of the settlements of which I'm aware, I'm not speaking from a position of lack of knowledge or guessing or saying, gee, a jury might do this or a jury might do that. I'm speaking from experience. And so I guess my challenge to you is understand that, it's 1 year's salary when it's really not, especially if it's a non-taxable event to you. But when I hear things like that, what I say is, okay, well, you show me what other verdicts or decisions or something that you're relying on, because that's the world we're playing in. We are playing in a world where, as I indicated, we're in the most conservative appellate district in the country. We are playing in a world where you have judges who really, Carl, don't care. I mean, as much as I want to believe that they care, and maybe sometimes one or two of them do, they don't.
Of course not.
And so then I look at it from the standpoint, okay, so if I'm looking at just numbers, and I have to look at it in a dispassionate, objective way. I didn't live through what you lived through. I know that. Nobody will have ever lived through what you lived through. But when I look at it from a strictly dispassionate, what is this case worth manner, when I look at it that way, then advice to you and my evaluation of your claim is that $200,000 is on the high side of settlements, especially at this point, and it is likely on the high side of what would happen at trial. And that's kind of where I am. I mean, it's not picking a number out of thin air and saying, this is what I think it should be. It's selecting a number and a range that in my mind's eye is something that I think is a likely, maybe not a likely, but an outcome, and it certainly is on the higher side. And I know the intangibles, which is the minute your case is settled, the press is going to be, what the hell? You're paying this guy all this kind of money, and you did this, you destroyed records, here's the stuff that he's saying, here's the information he has. Why are you people not in jail? It's those types of things that in some measure, at least at this point in time, you're kind of limited, not really limited, but sort of limited on what you can and can't talk about. Or at least what people will or will not pay attention to. Maybe that's a better way to say it.
Can I would tell you just wholeheartedly what I'm hanging my hat on. And it's the fact that we go through the process and what comes out. I know that, they're hiding the emails. They don't want to come out with the emails. I'm willing to bet that, the federal judge would make them, open those emails up to us. Maybe not, but that's a chance, and it's a chance that in my head I'm willing to take, and I think it's worth it because, one day this case, my case, and the Ronald Green case is going to go away. But I think the rulings that's given during my case and during Ronald Green's and his family case is going to matter to the people that comes behind me and us. It's not about to be the last, unfortunately, case like Ronald Green or any case, like it, or a Carl Cavalier speaking up and speaking out. I mean, at the very least, I don't want to say all came and got money and I left. I want to at least be able to say that, okay, this ruling affected, cases to come in the future, and maybe I'll go through the process and won't get no ruling in my damn favor. But I guess that's just the chance, you take when you do shit like this. And I get the position I put the firm in by saying, hey, I authorized this and then going back on it. But I had a chance to sit down and think about it, and I don't know that I'm not going. It's not sitting right with me. I was up 3 a.m. this morning, thinking about our phone call and thinking about our conversation, and that's no bullshit. That's no lie. Went to McDonald's fucking 5 a.m. this morning. Never did that in my life. But that's just where I'm at. That's where I'm hanging my hat on, Miss Joe. And I'm just being completely naked with you right now. That's what I'm hanging my hat on.
So here's what I would like for you to do, and me. I would like for both of us to kind of think about this over the weekend. I will be back Monday morning early, even though it's Labor Day. Mm-hmm. I'm happy to sit down with you and go through everything that I have in your file, everything that I can, show you and tangibly demonstrate to you and all that kind of stuff. And I want to kind of tell you that me, on your behalf, litigating for the quote principle of the matter in this situation means a lot of things, Carl. And one of those things is, I know you talk about rulings in my case and they'll be important and dispositive. They're not. The only rulings that are necessarily going to get published in your case, theoretically, except for maybe one or two minor rulings on evidence here and there, maybe, would be something from the U.S. Fifth Circuit, which would mean after trial or after, if the judge dismisses the 1983 claims, we can try to take that up to the Fifth Circuit, Mm-hmm. And those are the only rulings that get published, and not all of those get published. The case I'm telling you about, the one where the judge reversed it down to 0 and had to take it up to the Court of Appeal, and then the Court of Appeal sent it back, that case, it's an unpublished decision. It was one of the most significant male-on-male sexual harassment case rulings in the United States, and it's unpublished. It's those types of things that I understand in the world about. I want to make a point. I want people to know. My suggestion is always open your mouth and talk from a position of strength. Don't talk from a position of, I don't know what's going to happen with my case and that kind of thing. And then the final thing is, if the state police commission, and I don't necessarily think it's set in stone, but I sure as shit don't like those people. But if they were to rule that your termination was lawful, your claims in front of that federal judge are now significantly diminished because the law requires, as you know, that you exhaust all administrative remedies, and that unfortunately is the appeal to the to the state police commission. An unfavorable ruling from those people can dramatically impact both of your claims.
Correct.
And man, I don't want to see those people get away with murder, honestly, and that's the truth. So I'm just saying, let's think about it.
Yeah. I think if we go that route, I think we're assuming that. Well, I know the state police commission is the fucking state police commission. That's their playground. I get that, but I think we're assuming that this will go one way or this will go another way, and that's not. I mean, of course, 33 years of experience. I'm not even speaking to that at all. I would never do that. But I think, outside of your experience and your prior experience with them or with the courts or whatever like that, I think. Fuck, I'm just thinking in the terms of fuck. Let's fight. Let's fight and see what happens. And I guess that's the disconnect between my lack of experience and your experience. So I guess that's the bridge that's not connected. Because
that's what I'm saying. I can meet with you on Monday or Tuesday or whatever, but let's sit down and talk about it. There's nothing that needs to be done right now. If that makes any sense.
Okay.
I mean, they've submitted their shit up through the chain of command of the state. I don't know. We don't have any kind of thing from them, and none of that shit. And there's nothing. It's a holiday weekend.
Yeah, right.
So let's just think about it, And
Okay.
let's talk. If you're around, Tuesday or even Monday, it doesn't matter to me. Let's sit down and talk about it.
Okay, so there's nothing to do to say that, hey, tell them, hold on, put that shit on hold or nothing. There's nothing to do, nothing like that. All right.
No, they haven't been responded as to whether or not they have authority yet. So,
Oh, well, I guess that's a good thing, huh? I mean,
it's possible, yeah. I mean, I worry a lot because we've got the EEOC plugged in.
Mm-hmm.
The negotiations, the court system, everybody under the sun.
Yeah.
So, I mean, that is something that intangibly could also be negative for you. And it's something that I'm not willing to tell you, make a knee-jerk reaction and do this. That's just not smart.
Okay.
I think we take the weekend, we think about it, and, let's talk.
Okay. We can do that.
All right. And look, I'll find some of those opinions I was talking about and send them to you. I mean, I'm not a sky is falling person. And honestly, Carl, I've been doing this a long time now because it's financial for me. It's personal for me.